Welcome everyone to LegalVision's seminar today, which is on sponsoring foreign workers for your tech business. It's a pleasure to have you all here. My name is Yin Chiew. I'm the practice leader in the corporate immigration team at LegalVision, and I will be the speaker today on this topic. I just want to start with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present, and emerging traditional custodians and elders of this nation, in particular the Gadigal people and the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Before we begin, you will be emailed a copy of this webinar recording. Please submit your questions in the chat box and there will be time for us to go through them later in this webinar. And please complete the survey after the webinar. We would really appreciate your feedback. So we've got quite a bit to cover today, such as we want to talk about what kind of ANZSCO occupations the business, your tech business, may consider sponsoring a foreign worker on. What are some of the new emerging occupations? And then actually discussing the various pathways available for your tech business to sponsor foreign workers in these highly specialized, skilled niche sectors. So we'll talk about the employer-sponsored and employer-nominated visa, labor agreements, global talent employer-sponsored scheme, which is a form of labor agreement, and the global talent visa, which is very popular at the moment. I first want to talk to you about occupations. When your business is considering sponsoring a foreign worker, you really need to identify what is the appropriate ANZSCO occupations. And there's quite a lot in the technology and IT space. And some of the most common occupations a tech business may consider is appropriate occupations such as developer programmer, software engineer, cybersecurity engineer, DevOps engineer, penetration tester. And obviously the developer programmer, software engineer, they're really working on various proprietary platforms within your business, using programming skills, using their algorithm skills, and they may have certain niche specializations in blockchain, augmented reality, artificial intelligence, machine learning as well. So it is possible to use already existing ANZSCO occupations for that position, that niche position and niche skill set that you're trying to fill, and fit it within one of those occupations for the purpose of sponsoring a foreign worker. Blockchain has been talked about quite a lot over the last few years, and there are options for a tech business, for your tech business, to actually consider certain occupations where the position and the sponsored workers' skills require blockchain specialization. And so what I've identified here are two potential occupations, such as blockchain strategist. You can actually use the ANZSCO occupation code ICT business analyst, or blockchain planner manager. You can actually use the ANZSCO occupation ICT project manager. So there are options to fit in that particular skills required for the position and the skills of the foreign worker in an appropriate ANZSCO occupation. And I just want to stress this because it's very important. This should be the first step in assessing whether the business can sponsor a foreign worker is what is the occupation? What is the appropriate occupation? Occupations will allow the business to do a number of things, such as potentially nominate them for permanent residence at a later date, and other factors too. A new ANZSCO occupation that was recently introduced is user experience designer. And we'll talk a bit more about that later as well. The relevant government body is always, so the Department of Home Affairs is always in consultation with relevant stakeholders around what are emerging occupations. And they recognize that there are a lot of emerging occupations that are not covered in any ANZSCO occupation that tech businesses particularly really do need, and such as in data analytics, for instance, in digital processing. There's a lot that they're still trying to identify would be relevant to Australian businesses. So watch this space, because I'm of the view that as the department becomes more aware about some emerging occupations, they will update and amend the ANZSCO occupation, and ideally make some of those occupations available for businesses to nominate under appropriate employer-sponsored visas. So I really want to talk to you about employer-sponsored visas, which we're talking about the 482 or the 494. These are the temporary employer-sponsored visas, the 482 being a temporary work visa, the 494 being the temporary regional employer-sponsored work visa. And then the 186 is the employer-nominated permanent residence visa. Usually the applicant needs to be on a 482 first, but that's not always the case as well. As I said, the first step is identifying what is the appropriate occupation, and is it an occupation? Is it an eligible occupation for the purposes of the respective visa? So as you can see with the 482, a tech business can nominate the occupations of developer programmer, software engineer, ICT project manager. Remember, this was a blockchain planner or strategist, or ICT business analyst, which is also another blockchain specialization as well. But the applicant must have at least 2 years of work experience, typically in the nominated occupation or in a related field. Now with the 494, the regional employer-sponsored visa, similarly, a tech business can nominate the same occupations, but the work experience and the skills requirement of the applicant is a bit higher. They do need to have 3 years of work experience in the nominated occupation at the required skill level and a positive skills assessment. The 186, which is the permanent residence pathway, and there are 3 streams, but 2 in particular that would be relevant to consider. You can see that only 3 occupations from the relevant lists can be nominated by the tech business. So typically 1 stream, direct entry, will allow the business to nominate a foreign worker, provided that they have 3 years of work experience in the nominated occupation at the required skill level, and a positive skills assessment. Or nominate them if they are already sponsoring them on a 482 visa. They have been working with the same employer for 3 years in the same occupation. So what happens if the nominated occupation is not an eligible occupation on one of those visas. So if it's not an eligible occupation under a 482 visa, if it's not an eligible occupation under a 494, if it's not an eligible occupation under the 186, what options are available for your tech business? One option that may be available is a labour agreement, and specifically a company-specific labour agreement. This is not an application process. It is very much a business proposal that you put forward to the Department of Home Affairs and the Australian government, requesting that they agree to enter into a contract with you to sponsor foreign workers under different set of terms. Okay, under a company-specific labour agreement, you may be able to design your own position, occupation that's suitable and tailored for your tech business. And you can actually use multiple existing ANZSCO occupations to create your dream or your desired occupation. Now, obviously, that's going to be based on whether that occupation is so niche, so different, and so unique to your business. And often it is the case with tech businesses because you're either developing proprietary technology, you're needing highly skilled individuals with very niche skill set and expertise. So a company-specific labour agreement could potentially be an option. Now, there are already pre-approved concessions available under a company-specific labour agreement, and you would typically utilise the 482 visa or 494 visa and a 186 visa, but in accordance with the terms agreed to under the company-specific labour agreement. At times too, there would also be pathways to permanent residence available for your sponsored workers, typically after 3 years of being on a 482 visa, sponsored under the company-specific labour agreement. You do need to demonstrate quite a number of things when you are starting this process. And as I said, it is assessed by the Department of Home Affairs on a case-by-case basis. I just wanted to show you this slide in particular because often when we talk about labour agreements, it's hard to understand where it sits and where a business or why a business would utilise an existing visa pathway, such as the 482, 494, or the 186. As some of the attendees might know, when you start the process for employer sponsorship, the business needs to be an approved sponsor. With a company-specific labour agreement, and any labour agreement, in fact, that labour agreement is the sponsorship approval for the purposes of sponsoring on a 482, 494, or 186. So the company-specific labour agreement is the main step. Then you would have to lodge a nomination application for the appropriate visa, identifying the occupation that you have designed or created and it been approved for under the company-specific labour agreement, and then you lodge the visa application. Now, some occupations that you could potentially nominate or develop as part of a company-specific labour agreement is cybersecurity engineer. It is an ANZSCO occupation, but it's not an eligible occupation on any of the current skilled visas list. DevOps engineer, penetration tester, user experience designer, or could be a combination of all these and more as well. So it really depends on the business. The Global Talent Employer Sponsored Scheme is another form of labour agreement, but it's very much targeted towards two types of businesses. Established businesses, typically that operate in technology or the STEM field, or startup businesses as well. And there are quite a number of sort of guides, criteria that each type of business needs to meet. Generally speaking, a Global Talent Employer Sponsored Scheme labour agreement is suitable for highly innovative, tech-based businesses that are trying to fill very niche positions, and those positions, occupations are not identified at all in the skilled occupation list. It's still emerging, it's still new. There's not many people in the world that have those types of skills. So the position in and of itself has to be extremely innovative, extremely rare, and very new as well. So that's very much going to be dependent on the business, what the business actually does, and how specialized that position and those skills are. So with an established business, it's really only available to of employers that are already an accredited sponsor. And once approved, they can access typically up to 4 TSS visas per year, so they can sponsor for foreign workers on 482 visas per year. The labour agreement will be valid for 5 years. So if you think about it, that's 4 per year during the validity of the labour agreement. There will be pathways to permanent residence for your sponsored workers. Typically after 3 years, there may be concessions that you can negotiate, such as to age, such as to experience, such as to salary, such as to English as well. And so those are quite important for an established business in part of retaining their staff as well. So the startup stream is also extremely interesting as well, in that they need to operate in a STEM or tech-based field. They need to be endorsed by an independent GTES, which is the Global Talent Employer Sponsored Startup Advisory Panel. And there's quite a lot of individuals or businesses on that startup panel. They can access up to 5 positions per year, utilizing the 482 visa. There will be pathways to permanent residence as well, and there could be also concessions for the applicants in relation to age, English, things like that. The key difference between the business stream and the startup stream is a range of things, but of importance is the applicant's skill set. So for both stream, the applicant does need to have 3 years of work experience in the position, in the occupation that is new and innovative, that is rare and not readily able to be filled in the Australian labour market. So they need to have 3 years of work experience, and if you consider under the traditional 482 visa pathway, applicants typically need to have 2 years of work experience. The work experience level for a Global Talent Employer Sponsored labour agreement is higher. With the business stream, the salary needs to be equivalent to or higher than the Fair Work high income threshold, which I believe is about 163,000 at the moment. So we're talking about very innovative positions here, very highly specialized, very well paid as well for the business stream. For the startup stream, they need to have, or the business needs to at least offer a salary of at least $80,000. So the GTES labour agreement is potentially an option if your business fits into one of those streams, those categories. If you can show that by the business utilizing the labour agreement, that there's going to be a transfer of these very niche skill sets to Australians, that's going to help the business grow, expand, employ more Australian workers, those sorts of things as well. So the labour agreements are actually a fantastic way for the business, your business, to actually evolve and actually achieve its workforce and skills objective, if it's something that that the business is keen to explore. So I want to talk about the Global Talent Visa, which is not an employer-sponsored visa. It's actually an independent talent visa that the applicant would apply for on their own. It is a permanent residence visa as well. But why it's so important for tech businesses to be aware of it is because they may come across some applicants, some potential employees that they believe meet or satisfy the Global Talent Visa criteria. And as part of their support or endorsement of their application, they may want to be the Australian nominator. And I'll explain that in a moment, what that entails. So the Global Talent Visa was introduced in 2019, and it has since exploded in terms of attraction, in terms of demand, and the Australian government is very focused on attracting highly skilled, talented, internationally recognised applicants. The threshold is extremely high. The applicant does need to establish they have an internationally recognised record of exceptional and outstanding achievement in one of the target sectors, which we will talk about in a moment. They're still prominent in their field, so it's not, they weren't originally recognised, years ago and are no longer active in the field. They are prominent currently as we speak. They would be an asset to the Australian community, and they would have no difficulty obtaining employment or independently establishing themselves in Australia. And this may mean through either starting their own businesses. They have an Australian nominator, which can be an individual or an organisation, and they have a current salary of at least the Fair Work High Income threshold, which I believe has since increased to 163,000, or they have the ability to earn that income at some stage in their career. So I wanted to go on to describing the target sectors. So the target sectors were actually expanded upon in December 2020, which is great. And they include agri-food, ag-tech, financial services and fintech, health industries, digitech, defense, advanced manufacturing and space, energy, circular economy, infrastructure, tourism, resources, and education. So obviously, if for your tech business, you may actually be looking at potential employees, candidates that would be able to satisfy the criteria for the Global Talent Visa in the digitech space. And they could be a range of individuals with very specialized skill sets. Maybe they've been recognized for them, maybe they've been featured in the media, maybe they've created some proprietary, very innovative technology product that is widely used in the industry, that is widely praised in the industry. Maybe they're working with you in particular around very groundbreaking platforms or algorithms. There's a lot of things that you could consider here that where the applicant or the potential employee could fall into that target sector. What's really important to note is, as I explained, the criteria is a high bar. So the global talent team is really looking for applicants that are considered highly regarded above their constituents in the field. So those applicants that may have worked as a software engineer developer for many years or in other comparable roles may not necessarily be as competitive as another applicant that has that same experience but has gone above and beyond to contribute significantly to the innovation of that industry. And again, it's very much case by case as well. So before I go into this, how a tech business can potentially help is, if there is such an applicant, then you're really looking at whether you will, as an individual or as a company, be their Australian nominator for the purposes of supporting them in the global talent visa. An Australian nominator can be an Australian citizen, Australian permanent resident, or an Australian organisation as well. And if your business is also equally highly regarded in the field, also undertaking very groundbreaking work as well, then you could very well be a very suitable nominator for the applicant. And the good news is you don't have to sponsor them. A nomination is not a sponsorship that carries those obligations, those specific sponsorship obligations to the Department of Home Affairs. It's just an endorsement of the applicant's global talent. So I hope that was incredibly helpful. I'm sure there's some questions as well. Before we get to that, please feel free to download our employer guide to sponsoring foreign workers by accessing the handout section in your webinar panel. There's quite a bit of information there for you as well. So coming up is another LegalVision webinar, which is on Advertising 101, social media influencers and the law. That's going to take place on the 21st of July at 11 a.m. Australian Eastern Standard Time. So please register your interest at the link there. We hope to see you there as well. Okay, so let's see if there's any questions. So I have a few questions here, so bear with me for a moment. The first question is, what are the conditions, caveats to continue sponsoring international specialists into permanent residence and the impact and liability for employers? So that really depends on what is the nominated occupation. The caveats or conditions to the specific employer will be attached to that occupation. And they may include things like the business has to have a certain turnover, they have to employ a certain amount of people, they have to pay a base salary. That really will depend on the occupation as well. Typically, I find with a lot of tech-based roles, there are no such caveats to the occupation and therefore to the actual business. Now, having sponsorship obligations is a separate consideration. And if you do sponsor a foreign worker under a 482 visa or a 494 visa, and under any labour agreement, you do have specific sponsorship obligations that are monitored by the Australian Border Force, and there's quite a lot of them to actually cover in this session. The next question is, does the user experience designer occupation only apply to blockchain or across all? No, it can apply to all. Obviously, what you need to do is carefully read through and understand what the duties, tasks, and responsibilities are of that ANZSCO occupation. And depending on how you tailor it to the role in your company, that can include various other factors. So user experience designer is not an eligible occupation for the purposes of a 482, 494, or 186, but so you would have to use a company specific labor agreement. And in that of itself, you'd probably be sort of designing that occupation a little bit. So tweaking it a bit to tailor it to the actual position that's needed within your company. Okay, so I'll go on to the next question, which is, this is a two-part question. I applied to become a business sponsor. We are a 10-people startup, data and analytics. Does that limit how many people we can sponsor? And how long does it take to receive the accreditation? I think I may have to have a longer conversation with you about that. If you've applied for standard business sponsorship, then, and you haven't been a business sponsor before, then you're not going to get accreditation. Accreditation is only available for existing business sponsors, approved business sponsors, and typically they would have to have been an approved business sponsor for at least 1 to 2 years. But just say if you've applied for standard business sponsorship, then there is no limit to how many people you can sponsor. That's not the case with a labor agreement where there will be sort of a cap. But under the standard business sponsorship pathway, there is no limit, but you still need to demonstrate why you genuinely need all these people, and that's through the nomination and visa application as well. Okay, next question is, after sponsorship and visa grant, example 186, do I need to keep them employed for a period of time? You don't have a legal obligation to do that. It's more sort of an intention that the business will have that position available, and have the intention to employ that nominee in that position for at least 2 years. So at the time of lodging the 186, if the business has that intention and it's legitimate, then if something happens after the 186 visa is granted, such as downturn of business, you have to make them redundant, or they leave, then there's no legal obligations to ensure that that occurs. This I believe is a separate question. If I sponsor on a 186, which is the permanent residence visa, can I change the role during the process while visa is pending? No, you cannot. But if once the 186 is granted, you probably can. So if with a 186, you have to lodge a nomination and a visa application. In the nomination application, you have to identify the appropriate occupation. If you want to change the role, change the occupation during the processing of those applications, it's a new application. Okay, so here is another question. I have a team member who is not a permanent resident, working for 3 years as a casual in a cybersecurity role and started as a student intern. He's on a temporary visa, student to TR. His visa will expire in 4 to 5 months' time. Is it possible to sponsor him? If yes, which visa category? It's a difficult and it's a complex question, because what I would need to do is understand what his work experience is. So if it was on a casual basis, was it full-time? If it was not full-time, if it was sporadic, what did that involve? when he actually completed his degree, was the work experience post-qualification, those sorts of things. So once I've had a chance to review that, I can provide more in-depth advice. So maybe it might be best to consider contacting us to discuss that further. Great. So I think that was all the questions so far. As I said, please feel free to download the employer-sponsored guide as well. There's a lot of useful information there. You may want to consider becoming a LegalVision member, and you get access to all our lawyers across all our practice areas as well. And there will be a lot of additional features included in your membership, such as unlimited legal advice consultation calls and some document drafting and review. So there's a lot that could be available to you if you become a member as well. So we look forward to talking to you about that. So if you've attended this seminar today, you are welcome to request a complimentary consultation, and it will be with me in relation to any immigration questions you have about your foreign workers, ones that you're currently sponsoring, ones that you want to sponsor, what appropriate pathway is available to them, but also what is suitable and beneficial for the business as well. So attendees are eligible to receive that consultation to discuss this topic further, and to book in a complimentary consultation. Leave your contact details in the survey that will appear after this webinar, or you can email us at reply@legalvision.com.au and mention that you watched this webinar. So we really look forward to talking to you at some stage if you have further questions or you want to explore other options. Thank you so much, everyone, for your time, and I hope that was extremely helpful. Have a wonderful day and look forward to speaking to you soon.